Welcome, ladies and gentlemen, to the delayed regular meeting for November 28th, 2016 of the San Francisco Ethics Commission. I will first call the roll. Vice Chair Keene.
Here.
Commissioner Chu.
Here.
Commissioner Hayen has been excused due to illness, and we are expecting Commissioner Kopp to arrive shortly. And before calling for public comment, I want for the record to acknowledge that all commissioners received a cookie, which I understand is from the Friends of Ethics celebrating the passage of Proposition T, and I will have to check with the city attorney as to whether or not that gift of a cookie has to be reported on our Form 700. It doesn't? All right, good. Thank you. All right. Calling item number 2 on the agenda, public comment on matters appearing or not appearing on the agenda. And let me just say thank you to the Friends of Ethics for their support of Proposition T, and thank you for the cookie.
Yeah, it's very nice. I don't know about the $100 bill that's inside mine, though.
I didn't get 100.
Okay. Good evening, David Pilpel. Interested to hear about the cookie. Was it a chocolate chip cookie? Is it a sugar cookie? Very nice. A couple of quick things. Item 4, which was withdrawn from the agenda. I'm just wondering if you could announce if the waiver request was withdrawn or if the item was just continued for a future meeting.
Executive Director Powell, can you explain?
Yes, to clarify, the request for the waiver was withdrawn along with the item.
Got it. Okay. And the staff report used an old template, and it was a serif font. I was very concerned. Never mind. Anyway, the other general item I just wanted to call to your attention, some of the charts on item 5 and the executive director's report have different, it appears to me that they're in different colors or different somethings. If there's a way to convey that information better that's not in color, that would be helpful, because I was trying to figure it out. The particulars weren't that important to me. They may be important to others, but just something about the color. Otherwise, the information was great. There's lots of good information at tonight's meeting. Talk to you soon. Thanks.
Thank you. Any other public comment?
Hello, Larry Bush on behalf of Friends of Ethics. This is a general public comment, though you may be touching on it somewhat in some of the later reports. In looking over the campaign finance reports for this last November election, there are a number of independent expenditure committees that appear to be cycling money back and forth between each others. We found San Franciscans for a City That Works, Friends of the Mayor, No Recall, No on DHL&M, Protect San Francisco, San Franciscans Against Wasteful Spending, Progress San Francisco, and then several other better-known, long-lasting groups like SPUR and SF Forward, where they would have some of the same consultants. In some cases, they also had the same principal officer, and they often had the same donor, and sometimes money would go from one committee to another committee and then to a third committee. So the whole issue of tracking the money gets very convoluted. I was tempted to get butcher paper and a magic marker and try and follow it, but I thought I'd just ask if you all would please do that as a public service. Thank you.
Thank you.
I won a case at the State Court of Appeal. I didn't have a lawyer, it was just me, and I had no one to even look over the paperwork. And This had to do with a woman who I don't know. There was no basis for the filing. There was no evidence. I was not properly served. My due process rights were violated. And they charged under the wrong statute. And this woman's name is Barbara Sklar, a commissioner with the Arts Commission. There's really very little paperwork on her. She claims to have served under 5 mayors, but there's no record of that anywhere. And for me, it was very distressing to have these malicious charges put on me. I would say, I mean, it took a year of my time. I spent a lot of time in the law library myself and did everything on my own, but I'm sure it cost the city a lot of money. And there was no investigation at all. And I think that it was a waste of time. It was a malicious filing, and it was meant to keep me out of 401 Vanessa Avenue. And as an artist, to be prevented from entering a building that is primarily for the arts, that was a very... I still can't make sense out of it. And I was hoping that by coming here talking about it, it would make it less surreal for me. It was awful. I wouldn't wish it on anyone.
Thank you. Any other public comment? I turn to agenda item 3, discussion and possible action on draft minutes for the Commission's October 17, 2016 special meeting. Do any of the commissioners have any additions, corrections?
Move approval.
Second.
Right. Any public comment on the draft minutes of the October 17th special meeting? I now call the question. All those in favor?
Aye.
Aye.
Opposed? Hearing none, the minutes are adopted 3-0. And the record will reflect that Commissioner Kopp has just arrived, fortunately, as we move into the more substantive part of our agenda. As the record reflects, item number 4 was withdrawn. Number 5, discussion of enforcement program. Good evening.
Good evening, Mr. Chairman. Apologize for my lateness.
That's quite all right. Discussion of enforcement program report, an updated, highlighted various programmatic issues and activities of the Commission's Enforcement Division. And I would ask Ms. Blum if you would give us a little introduction and discussion concerning item number 5.
Thank you, Chair Rennie. I will turn it over to Deputy Director, our Director of Enforcement and Legal Affairs, Jessica Blum.
Good evening, Commissioners. In the enforcement report this month, I included a small synopsis, a very short synopsis of the fairly complicated Sunshine Ordinance regulations. These are the enforcement regulations for handling matters under the Sunshine Ordinance that this Commission passed a couple of years ago. I think it was maybe even 3 years ago now. I did this because there are several matters on the agenda tonight that deal with the Sunshine Ordinance, so I wanted to give you some context before launching into those matters. Just briefly to summarize what I've written, there are basically 2 tracks under the Sunshine Ordinance. The first track is what is commonly referred to as a Chapter 2 referral. Those matters are matters that the Sunshine Ordinance Task Force has already considered, and they've already looked at the factual matter, considered the matter at a hearing, usually before committee and then again before the full task force, and issued some sort of order and determination for what they think has happened. And an example of that we had recently was the Steve Kava calendaring matter. The task force considered all the evidence and sent that matter over here for referral. None of the matters on the agenda tonight are task force referrals, but I thought that I would include that as sort of a, so you can see the difference between the two. The Chapter 3 referrals are matters that the Commission ostensibly has authority to hear as an original matter, so you have original jurisdiction to hear these matters. The first type of Chapter 3 matters are matters where the complainant is alleging a willful violation of the Sunshine Ordinance by an elected official or a department head. The second is where the task force has issued an order and some time has gone by and neither the city attorney nor district attorney have taken it, have enforce that order despite being asked to do so, at that point you could take up the matter as a matter of original jurisdiction. And then the third is when staff initiates a complaint for a violation of the Sunshine Ordinance on its own motion, basically on its own initiation. The first two subjects under that tract are clearly articulated in the Sunshine Ordinance itself. The third, a staff-initiated complaint, is not really supported by the Sunshine Ordinance itself. So that's one of the things we'll be taking a look at when we look at the Sunshine Ordinance regulations. Unless it involves a matter where there's an allegation that an elected official or department head has committed a willful violation of the Sunshine Ordinance, we don't find evidence that staff has the authority to really just launch an investigation into any kind of violation of the Sunshine Ordinance. Those matters should really go before the Sunshine Ordinance Task Force first. Nevertheless, those are the types of matters that we have tonight. And staff, over the last several months, has initiated its own investigations into various complaints, and we're presenting recommendations and reports to you on those as separate agenda items later. As you know, the available relief for anybody who has a Sunshine Ordinance complaint before the task force is the same, whether it's under Chapter 2 or 3. I'm sorry, did someone say something? Oh, I can't hear. But the respondent has to cease. You can order the respondent to cease and desist the violation or produce the records. You can ask the executive director to post on the commission's website a finding that the respondent violated the Sunshine Ordinance. Or you can ask the executive director to issue a warning letter to the respondent and inform the respondent's appointment authority of the violation. That's really the extent of our authority to do anything about a violation of the Sunshine Ordinance. We don't have penalty authority or anything like that. So are there any questions on that portion of the report?
Any commissioners have any questions? I in reading your memorandum, I did have a number of questions as to, in the second paragraph under Chapter 2 referrals, you say upon receipt of these referrals, staff reviews the SOTF's findings, evidence, and order. Staff may then prepare a memorandum for the Commission's consideration if we believe further analysis would prove beneficial. What does staff do if it doesn't think it needs further analysis?
It just is a pass-through referral. And I think most of the referrals that you've received from the task force have been pass-through referrals, where you will only receive the task force's order and then the party's response to that order, and staff stays out of it.
Okay.
I think that was the original contemplation of Chapter 2. But in the Steve Cava matter, for example, the facts were so confusing that staff felt it should weigh in to sort of help the public and the commission along.
Thanks.
And then the remainder of the report is our general update that we give every month. You'll note that our official complaint total is up to 30 now. We initiated a number of complaints during the election season. There will likely be more to come as a result of complaints that were filed with us over the election season. They're under preliminary review now, so you'll also note that the number of matters in preliminary review has gone up. Oops, and I don't have the chart. 87. Lena's telling me 87 matters are now in preliminary review. Thank you. And then finally, on the end of the document, the matters that are with the Bureau of Delinquent Revenue. Oh, 89. Sorry, 89 matters in preliminary review are the matters with the Bureau of Delinquent Revenue, which they're diligently collecting for us, and we commend them for the great job.
Yes, Commissioner Chu.
Jessica, in terms of preliminary review, is it only the executive director who has the authority to make the determination whether or not a potential violation has occurred?
Yes, the executive director has to determine whether we have reason to believe a violation has occurred. Okay. So after we go through the complaint, we just make an assessment of whether or not it's within our jurisdiction or whether it merits further investigation. If it merits further investigation, we send it on to the city attorney as mandated by the charter and the district attorney. in that matter. Once it's been sent to the city attorney, district attorney gets logged as a formal complaint.
I see. So there would be no possibility of delegating that review or sharing some of the workload with you,
Well,
for example?
as a practical matter, the staff, all of the investigations and enforcement programs assist
Okay.
in that review, and we present the executive director with a memorandum and a recommendation.
Chairman.
Commissioner Kopp?
I'm looking at page 4, the report. Active Bureau of Delinquent Revenue referrals, of which there are, 5 identified, 2 against the same it's the same case, I guess. Chris Jackson, same case.
Different cases. He ran for election
Different
twice.
cases, all right. And one of them, and one only, a year ago was reduced to judgment. Do you get a report from the tax collector on what he's doing about collecting the judgment?
We don't get regular updates, but when we inquire, they send us updates. Our most recent update on this particular judgment was just within the last 4 weeks, and they've attempted to collect, but Mr. Jackson doesn't have any assets in the city.
How have they tried to collect?
They did not go into details about how.
Ask them if they've conducted an order of examination.
Okay.
And asked them also, I'm through the chair with such a request, what have they done on this committee to elect Norman for supervisor? That's a referral going on 1.5 years. Same thing with Bob Squarey for District 7. Same thing with Isabel Urbano, which is 6 months or so. And then the second case, of course, is September 26th of this year. I'd like to know what they're actually doing.
Sure.
And then the second part of the question, same subject matter, is my first meeting, we acted to penalize Lynette Sweet. That's not on here. Is that because it hasn't been referred for collection?
No, she has. It's not. The order isn't final for 30 days, and then she has some period of time after that to pay. And I couldn't tell you how much, but to pay to the Ethics Commission affirmatively. I think, if I recall, the total is 90 days post order.
Well, give me that information.
Sure.
Informally or otherwise. The other type of question I have is on page 3, you summarize the type of complaints. But then on page, guess it's attachment 1, so it's got 1 under it. There are different words used to describe age of matters in preliminary review as of November 15th. For example, I don't get it.
Oh, I see what you mean. So
You
ethics.
see what I mean?
Yeah.
Well, most of them do, I guess. I don't know. You've got, okay, I guess they are the same or just a different word or something.
Yeah, so for the purposes of the table 1 on page 3 of the actual report, I broke out conflict of interest and governmental ethics. Governmental ethics being things like having political activity on city property or something like that, whereas the conflict of interest would be a direct and financial interest in some activity that was happening. But for the purposes of the tables, they've never been broken out that way, so we didn't want to make that data We want to make the data look like what you've normally seen. So ethics includes both conflict of interest and governmental ethics activity.
Okay. I've never seen it, so it's a new boy out in the block.
Sure.
All right, thanks, Mr. Chairman.
Any other commissioners' comments? I will call for public comment on agenda item number 5.
Unfortunately, the closed captioning isn't working, and I have a hearing issue. But when discussing what I thought were the findings of the Sunshine Ordinance Task Force, reviewing them and making sure they're supported by what was presented to them and the committees there by the task force. And in any case, I understood that if you get a case that's referred from the task force, you have to hear it in a show cause hearing. In a show cause hearing, as I understand it, the respondent has the burden of establishing that whatever the complaint was, it isn't merit. There's no merit to it. What I heard was that the staff here is going to evaluate the task force findings, which include at least 2 or 3 meetings of the full task force and at least 2 meetings of a committee of the task force. And since a show cause hearing is based on what the task force produces, I don't think it's appropriate for your staff to second guess the task force, if that's what's happening.
Thank you. Any other public comment on agenda item 5?
David Pilpel, I was very interested in this item, and I appreciate the summary that Jessica provided. I do recall that there was a difference between a Chapter 2 referral and a Chapter 3 referral or matter, and it did have to do with whether the burden was shifted. So I'm sure that staff can talk about that. The last version of the regs were adopted in January of 2013 as indicated. I believe that there was a follow-up hearing in the fall of 2013, and there was discussion about the handling of referrals from the task force. And if I recall correctly, there was a memo from then Deputy Director, Deputy Director, the former,
Minardi?
Yes, Minardi, to the task force that memorialized the discussion that the commission had in that meeting. As I say, I think it was in the fall of 2013, and this memo was either in December of 2013 or early 2014. I probably have it somewhere in my files. But I'm sure you can find that, and I think it may have clarified some of the understandings, but it did not go back and change the regs. There was a determination at that time that the regs didn't need to be changed. It was just a question of how things were handled. I don't know if you found that in going through stuff.
I have, yeah.
Okay. So I did remember it correctly?
Yes.
Okay. One of the things that I was concerned about, the regs sort of contemplate, and the memo contemplates, and tonight's agenda includes a number of Sunshine Ordinance complaints filed directly with the Commission. There have been a couple of instances of that happening over time. I have never been a fan of that. I am of the belief that the Sunshine Ordinance really provides for complaints about violations of the ordinance to be routed to the task force, and that's the place to hear complaints, whether they handle them properly or not. If there's a referral from the task force, it comes before the Commission. But this idea of having 2 venues that complainants can go to, either the task force or this Commission, or both potentially, on the same underlying facts, is troubling, and I don't think that was the intent. I don't know if you ever asked the city attorney for an opinion on the ordinance. It's a little vague, admittedly, on this 40 days if no enforcement authority, if no enforcement action is taken. But I do think that that relates to enforcement of an order by the task force, and that's something that's kind of glossed over here. So this whole question of original jurisdiction, I think, is important. The amount of detail that's here about complaints, preliminary and formal, is very helpful, as I've said before, and we can talk about BDR another time. I think the questions from Commissioner Kopp were right on.
All right. Commissioner Kopp, I believe, has a question you may want to ask Mr. Phillips.
What is it? Well, I'll ask the city attorney. What is it that the Sunshine Ordinance Task Force has the legal power to do that the Ethics Commission doesn't?
The task force basically issues orders of determination, which are then referred to ethics. But in terms of like what can actually be, what the task force can itself impose, the answer is simply referring it to the Ethics Commission.
No, that's not my question. What subject matter?
Oh, the subject matter.
Does the Sunshine Ordinance Task Force have legal jurisdiction over which the Ethics Commission does not?
None. It's basically the Sunshine Ordinance Task Force has jurisdiction exclusively over sunshine ordinance violations, but there's nothing
and
that
sunshine means what? Open meetings versus closed meetings?
Right. So the Sunshine Ordinance was enacted and then amended. It's in Chapter 67 of the Administrative Code.
Do you know the year it was enacted? Because I saw 1999.
1993 by the Board of Supervisors, and
then it's been
signed by then Mayor Jordan.
One of these documents said 99. Thank you.
Judge Kopp, if I could interject, I don't want to disagree with the City Attorney's Office, but the Sunshine Ordinance Task Force does not appear to have jurisdiction over allegations of willful misconduct by elected officials or department heads. That's vested in the Ethics Commission. All other allegations of violations of the Sunshine Ordinance, which includes open meetings and public records requests and responses, is with the Sunshine Ordinance Task Force in terms of investigation.
To the exclusion of the Ethics Commission?
Well, that's the language of the Sunshine Ordinance itself would suggest that, yes. And the Ethics Commission is to handle the enforcement of orders issued by the task force. So if you think of yourselves as the enforcement authority for another body that does an evidentiary inquiry and investigation, and it makes the order, that's how the ordinance is set up right now.
I think of myself as trying for the taxpayers to avoid duplication.
Mm-hmm.
But I've got to do more studying.
Mm-hmm. If I could respond to something Mr. Pilpel said, I did include, and I did not include in my verbal. I'm sorry, what? Oh, I did not include in my verbal summary, but I did include in my written summary that the respondent bears the burden of proof in Sunshine Ordinance Task Force referrals to demonstrate he did not violate the law. And I'll add that staff's only role in a task force referral would be to clarify or help explain the Commission's authority, because it is so confusing. We wouldn't interfere with this task force factual findings.
Thank you, and I'm happy to discuss more with.
Pilpel had over 3 minutes. His public comment time is finished.
I just wanted to say thank you, and I'm happy to discuss further with Jessica this question of jurisdiction. Thanks.
All right, thank you. Any other public comment on agenda item 5?
Yeah, public comment on agenda item 5. The reason why a member of the public might make a Sunshine referral directly to the Ethics Commission as opposed to the task force is because of the makeup of the task force. While David Pilpel did not identify himself as a member of the public, he was on the task force for quite a long period of time, and a lot of the things he did were illegal, they were ethically wrong, and there were a number of people, including myself, who came to the Ethics Commission because they did not feel that their complaints were heard fairly.
And who are you?
Is Anne Treboux?
Pardon me?
Anne Treboux.
Thank you.
Thank you. All right, hearing no other comments, no other questions by the commissioner, turn to agenda item number 6, which is discussion and possible action on staff's report and recommendation for handling Ethics Commission complaint number 031600621. Is San Francisco Urban Forest Commission versus John Rahaim and Sarah Jones and Mr. Grossman. I believe that is subject to your comment.
Okay, well, I understand I have 10 minutes, actually. Is that right?
Correct.
I won't have 10 minutes to say. And actually, I was going to begin my comments differently until I heard this last discussion. I'm probably one of the few people that was engaged directly with Mr. St. Croix in drafting the regulations that ultimately were adopted. He didn't follow many of the recommendations of the people on the task force that were interested and decided to do things his way. But I did discuss the issue of the burden of proof directly with a couple of the then commissioners, and they felt that that was the best way to go, rather than just enforcing, which is what the Sunshine Ordinance says. My complaint is a little different, but I think in background I even wonder whether any of the staff that have come aboard recently have actually been to the task force meetings, because so much of their business could and possibly should be driven by what the task force does. The complaints that are filed directly with the commission are very limited to department heads and elected officials. And the bulk, I'm sure, of what you get from the task force involves other people. I will try to make this short and direct it to the single issue raised by the complaint, which is the Planning Department's violation of the Sunshine Ordinance by its failure to provide public access to information that planning should have input into the two indices it created to provide the public with public information in its statutory role under CEQA and the San Francisco Administrative Code. I think this goes further to my point about the staff's orientation about public access. California has, in its Constitution, the right of public access. It's constitutional here. It's not a statute, and it's not some board issuing a rule. And what it says, actually, an important part for our discussion is that a statute, court rule, or other authority, including those in effect on the effective date of this subdivision, shall be broadly construed if it furthers the people's right of access, and narrowly construed if it limits the right of access. So when you construe 6729, that's the way it has to be construed. But this complaint is not about the complainant not receiving copies of public records sought under a separate and different records request. This is a complaint about the public using its access to look at the information at the heart of the Planning Department's responsibility as the gatekeeper for CEQA, the state and city environmental laws. If you're not familiar with CEQA, you should know it affects almost everything that planning touches, from reviewing its own and other initiated legislation to its review of the small projects that are sought to be built in the city. So if they want to completely tear up Geary Boulevard to set in some red bus lanes, it's got to go through CEQA. And it's got to be reviewed by an agency, and in San Francisco it would be the planning department unless, and I could go into that, but I won't. But it's the most important environmental review that there can be. So the complaint is really about the planning department to provide the path to that information, which is mandated by Section 6729. It's not about the records that might have been identified if the planning department had fully complied with 6729 of the ordinance, which it has not. Setting up the index doesn't provide any information. It just provides the structure for the information. And as we know, under the Sunshine Ordinance, the content of any public record is public information, and it is accessible to the public. So the complaint is strictly focused on their deliberate violation of 6729. Now, that provision has been in effect at least since the year 2000, 16 years. The scope and level of planning's role and responsibility under CEQA and the city's administrative code has to be understood to comprehend the significance of planning's noncompliance with 6729 for 16 years. Right now, the planning's environmental group, now this is the group that deals with CEQA and the city administrative code. They have 13 separate subgroups divided into various aspects of the kind of review required of the focus, and has a staff of probably more than 30 people. Now, all of this is happening at the same time because that's all they do. So you figure out the number of CEQA-related reviews since this group was set up probably is staggering. It's probably thousands. So how can a member of the public like me quickly determine when and whether there was a CEQA review of a particular public or private project or of legislation without accessing the indices into which planning should have input this information and maintained it for all these years? Certainly since 6729 became law, which I think it was expanded in the year 2000, and the indices were put in place by planning filing with the city administration. And the idea that just by creating the indices they've complied, which is what the report says, is nonsense. It's not the setting up of the indices, it's the information that should have been put in there all these years. I know because I've asked for CEQA reviews, and what I get is a single sheet of paper, and that's the end of it. Where's the file? Well, we really don't keep notes. I'm talking about the reviewer. We don't keep notes. We don't show the amount of time we spent. You know, it's basically an empty well. And I'm talking about when they review legislation. I'm not just talking about a, 3-story walk-up. I'm talking about the Better Streets Plan amendment, which was almost 200 pages long. The one-page report was, it's exempt, period. No notes, nothing to show how much time was spent reviewing it, nothing. So, in my view, they don't have any excuses or there are any rationales for their failure to comply. The fact is that once I filed the complaint, they should have gotten right on it. But here we are. What? So I filed it in April, May, June, July, August, September, October, November. 7 months later, nothing. Nothing.
I interrupt.
Yes.
But how do they get right on it?
Huh?
If they don't have records? How do they get right on it? I mean, as I understand your complaint, it's based on the fact that they don't keep notes, or they don't keep
notes.
Paper.
I have
so how do they
emails
get
that
right
say,
on it? What do they got to do?
look,
Go back and
They don't keep notes, and they don't keep records of their time.
Yeah.
Occasionally, what you will see is an email. I've made about 3 or 4 records requests dealing with specific legislation, and recently with this Geary Avenue rapid transit project. If I only got 25 seconds left?
No, I'd move whatever.
Anyway, the main thing is, I think in my response to the report, I made it clear that I don't get how they could miss the issue. How could you miss the issue? I don't understand that. There's only one question. You either input the information and make it accessible, or you don't. And they haven't.
Well, Mr. Grossman, and I'm part of the problem I have is I don't know what it is you're saying they should have produced for you that they don't, that they didn't, but that they do have.
It's not a question. This is not a records request. My request to them was to identify the records that they have put into the system, into these 2 indices. I didn't ask for any. I made 2 records requests. One was a general request related to the amendment to the Better Streets Plan,
Right.
and I got a ton of stuff, hundreds, they say. It might have been hundreds, but I'm not sure.
Right.
But I made a special request in this immediate disclosure request, and it's right in the complaint. I talked about 6729. I didn't talk about where are my records, which would be 6721.
But I'm just trying to understand. You say they produced 100 or whatever it is in response to your request. What is it that they didn't produce?
They didn't produce any evidence that they had started to fill up the 2 indices. That's part of it.
Online, you mean?
Look, it's hard to separate the record from the information, but that's really what it is. In the database, it's just information. It's not the record itself. So they should have that information, public information, in these 2 indices. Why else create them? You know, it's like any database. I could create a database on Excel that allows for all this and then never fill in any of the blanks. And that's what this complaint was about.
Well, if I may, it sounds to me, I know Commissioner Keen
6729 requires them to provide.
It sounds to me, Mr. Grossman, that either they don't make notes as they look at the CEQA statutes and they look at the CEQA regulations, or if they do, they toss them. And what you're trying to do is make them, A, keep notes on what they looked at, what statutes, what regulations, and B, if they made notes, keep the notes. Isn't that it?
And make it accessible.
I don't
if
know.
If they do 100 CEQA reviews a year, and it's probably closer to 1,000,
Yeah.
how do they keep track of them? How does the public know which ones they've done or not?
What was in the hundreds of pages you got?
For the first request?
Uh-huh.
Yeah, well, it was everything. It was the emails that were sent among the planners who were rewriting the Better Streets Plan through this amendment.
So it wasn't strictly on CEQA.
It wasn't on CEQA.
All right. Thank you.
If they did a CEQA review, it should have been in there. But they did not do a full review. They exempted it under an exemption provision that they use indiscriminately. But I'm not a CEQA expert, and let me tell you, that is really complicated stuff.
Commissioner Keene.
Yeah, Mr. Grossman, I'm also having a lot of trouble with what you're indicating is wrong with this organization in terms of some of the things that you said. So let me just see if I can specifically go to one of the things that you said that they were dealing with that I'm certainly familiar with and I have some concerns about as well, and that is you're talking about the redlining aspect of Geary Boulevard.
Yeah.
And this group, this organization would have the authority to go ahead and look to see whether or not that is something that properly should be done in terms of the bus lanes and all of that. That's a large thing in our city. This is a group that, and you said that in regard to your contact with this group in regard to a matter like that, that they would have dealt with. And you asked them, well, what did you do with it? They told you, well, we don't keep any files. We don't have any files. We have nothing to tell you as to how we arrived at whatever decision we arrived at. Am I accurately summarizing what you just said on that issue?
Okay, that's actually a little more complicated. The Geary project, as they call it, BRT, bus lane project.
Well, what is it that they wouldn't have a file on? I mean, you said generally that
okay,
my gut. Wait a minute. Let me because
explain.
I got out of you this general statement that when you address them for various things on anything, they had told you. We have no files, and we don't know what we do.
Okay.
This was what we did, but we have no idea how we got that. Is that true? Is that?
Well, it's partially true. I gave a poor example because with the Geary Street project, actually, the planning department was hired by SFM Transit Authority to do the EIS review. That was all done under contract, so it would not necessarily fall in within this. But the Better Streets Plan amendment clearly did, was clearly all planning. They wrote the law, and they got, I think, the president of the board to introduce it. They had their hands all over it. And in that, if you want to really drill down on it, that had an environmental negative to it because what it did was it eliminated street tree plantings in many situations. They gave the planning code had a provision that if you did certain things, built a new building, put in a garage, whatever, you had to put in a street tree. And if you didn't, then you had to pay an in lieu fee in place of it. What the amendment to the Better Streets Plan did, it changed the way that operated and gave the project developer a credit if there was an existing tree there, which meant that they could be losing 100 or 200 or 300 trees a year, and they didn't even consider that an environmental issue, and we know how important street trees are, the urban forest. That was my interest. So when I found out...
How do you know they didn't consider that?
Pardon?
How do you know they didn't consider that?
Because there are no notes.
Yeah, but that gets back to what I've said, that what you're asking for by way of relief is some law requiring notes. And B...
I beg to differ, Quentin, and
right.
You know I do that very, very cautiously.
No, go ahead. How do you differ?
I differ with you. They don't have to do notes if they don't want to. But they have to say they didn't do notes and put it in the indices.
All right, okay.
No notes.
All right.
Because the public is entitled to know what records are available on that project. And if they say there are no notes, there are no notes.
Just as a footnote, I'm familiar with the project. I'm familiar with, I'll call it turmoil. It's not quite turmoil, but it may become. And maybe there should be a law that says if you're going to reach a conclusion of a CEQA exemption, you lay it out for the public on why.
Well, yeah, because
But I think that's above our pay grade.
Of course it is. But the point is that 6729 was designed to improve public access so that the departments who do regular kinds of business, like the planning department, will make it known what they do.
Yeah.
And where it's, what's available. They do it for other things. If you want to look at a permit application, they're all over that. You can see that.
When you say you can see it where?
On their website.
But is your complaint that they didn't put this on their website?
No. My complaint is they didn't fill it out, and it was, I think 6729 actually has words that could be construed. It has to be on its website.
But I mean, the environmental impact report is available, isn't it?
It is, sure.
Yeah.
But how do you know there is one?
Well, isn't there?
You used to ask for it.
Oh.
Now, wasn't your complaint, though, that they didn't put it on their website so you could download it?
If that's what I do, actually, with permits.
Right.
It seems to me that the purpose of that indexing was to make available to the public in ways that are modern what information is available on these
But in this
things.
index that you refer to, it lists subject matters.
Yeah.
Then you go to that index and you ask them for the documents.
No, what you do is, if it's accessible on their website, like their permits are, you can find it maybe with an address.
I understand all of that, but I'm saying that if they've given you an index, can't you just ask them and say, give me everything you've got under this category?
Yeah, you could.
Did you?
Huh?
Did you?
I don't have to.
You mean they have to?
I'm entitled to do it the way the statute outlines it and says it should be done. Planning has, listen, if I could tell you stories about planning that you wouldn't believe.
Mr. Chief.
Yeah, but Mr. Grossman, on the website with the indices, it does say that if the record is available, you can click on it and download. But if it's not available, they do give a name and number to contact to make arrangements to see the actual paper copy.
Yeah.
How does that not meet your need?
It doesn't meet my needs because it doesn't meet 6729. I shouldn't have to ask for it. I don't have to ask for a copy of a permit because I can get that off their website. If I could, I've been dealing with planning and Department of Public Works for at least 10 years. And I've gotten used to the things they do that are not permitted under the Sunshine Ordinance. Okay? The Planning Department has created the Office of Public Records, a nameless position, so that if I submit a record request to a specific planner, like I did with Sarah Jones, she doesn't do anything with me. She sends it to this nameless person, and then I get either we don't have anything, or I might get, if there are too many records, well, we'll put them on a CD, send us $1, and we'll mail it to you, okay? Even though there's nothing in the Sunshine Ordinance that says they should do it that way. And but I learned to accept that kind of nonsense. Even though I'm not well enough to get in a car anymore and drive down to get what I want, I do expect that they would observe. So if I send it to the custodian, which is what 67 21A says, or B, that person should be responding to me, not somebody whose name I don't know and who puts it in a format that is not one they regularly use for their own record keeping.
Thank you.
You know,
I think your time is up. Well,
oh yeah,
well
it's
past
definitely
it.
up.
And
I just had one more thing I wanted to say.
I'd move 3 minutes.
I was demoralized by the report because it was so off base, and because it was so poorly written, and because it lacked complete understanding of public access. And that's why I made a big deal out of the constitutional provision, because there are cases that are going to come up here which will depend on statutory interpretation. And if they're looked at like any other case of interpretation, that constitutional provision will be reflected, and it's important.
I would ask Ms. Pelham, notice was sent to the respondents in this matter, were they not?
Yes.
And is there anyone here from either the Planning Department or Sarah Jones or John Rahaim? Do I hear any motion from any commissioners? Whether or not...
Well, before there's a motion,
Pardon me?
Mr. Chairman, before any motion, may I
Sure.
just be, I'm trying to think of CEQA law. As I remember CEQA law, if a government department, planning department, or some other entity concludes that a project is exempt, at least the custom and practice was there'd be a written explanation for it. It would be laid out in writing. And part of Mr. Grossman's complaint goes beyond my technical prowess as to how this should be done. But the other part seems to be that these deliberations in the planning department, at least hypothetically, are conducted orally between employees of the planning department or employee of the planning department, some other department of city government, and that there ought to be a law that makes them put it in writing. That's what I glean from this. And maybe there should, but I always thought with CEQA, you've got to lay it out, why it's exempt. It's a major issue.
But my understanding from what Mr. Grossman has said is that there may well be all of those documents, but because they aren't online, he feels it's a violation of the ordinance.
That is not correct of my position.
All right. Tell me how I'm incorrect on that.
Pardon?
Explain to me how that is incorrect.
I have the right to know if there was a CEQA review and what the conclusion was.
Wait, but didn't you say it was assigned to, it's an MTA project, take Geary Boulevard.
Yeah.
It was assigned to the planning department to do the CEQA review. And planning department concludes that it was exempt. Is that correct?
Actually not.
That's not correct.
They haven't concluded anything.
They what?
They haven't concluded anything. That was done by the SFCTA as the agency, the lead agency on the project. All they got from planning was input. I'm still looking at all of
All right, so MTA, as a matter of public record, issued a finding that it's exempt?
Not yet. The lead agency is the CTA, not the MTA.
CTA.
Yeah, County Transportation Authority.
All right.
That must be
I'm
my
puzzled.
phone.
I'm hopelessly confused. If I were to say I was puzzled, I'd be ahead of the game here.
Well, I don't.
No,
maybe,
I'm sorry. I mean, I'm not talking to you, Mr. Grossman. I'm just.
As am I.
The chair was soliciting whether or not we have any motions. I wouldn't know what to move. I don't know what any. I have no idea what any of this is even about. In terms of after listening to, I respect Mr. Grossman a lot, but I'm totally lost on this item.
Well, it's such a simple thing. Either they put the data in the indices or not, and if they don't do it, they're not complying with 6729. That was the whole.
The city attorney is going to help us out here, Mr. Grossman.
So this is I think it's important to come back to what is the alleged violation and who is alleged to have made the mistake. And so 67.29 is a requirement that the city administrator keep basically a website that includes, basically a description of certain categories of documents. That is not a requirement that is imposed upon the planning department. It's not a requirement that's imposed on any individual employee like Director Ram or the planner at issue here. So if you look at the language of 67.29, it just simply requires the city to prepare an index of public records. The city administrator is responsible for that index, and then there are certain requirements that the index has to clearly and meaningfully describe as much as practicable basically what the categories of documents are. That has nothing to do with the planning department or any individual employee within the planning department. So my view is I don't see how you could find a violation against either of the two respondents here because they don't have a responsibility.
I'm sorry.
Mr. Grossman?
Listen, I've
Mr.
listened.
Grossman?
Okay.
You'll have your chance. Continue.
So that's my point. This is not the way the complaint is framed. It's not a request for particular specific documents. It's just an allegation that the online index is deficient, and whether or not that's true is irrelevant for purposes of this complaint because the allegation is that Director Ram and one of the planners is against them specifically.
But the question, following up, which is, if the department files its index or indices as to what records it has, is it obligated to put on its website all the records that fall under whatever the index indicates is the subject matter?
It's not a requirement that's imposed on the planning department.
Is it
imposed on the city administrator?
It says that the index shall be continuously maintained on the World Wide Web, so I don't think that necessarily means that every document the index itself has to be on the Internet, but that doesn't mean that there has to be a comprehensive, set of links to every single document.
That's covered by the index.
Well, how are you going to construe it against their doing that in the face of the Section 3B of the Constitution? I was just about to say something, and I'm going to say it. The Sunshine Ordinance has a specific provision dealing with the city attorney. And the city attorney cannot aid or assist any department or agency or unit of the government, city government, in denying access to a public record. That's a specific provision in the ordinance. And what he just did was exactly what he cannot do.
He hasn't denied us access to any records or denied you access to it.
Well, look, you can be unhappy with me, that's fine. But you're all lawyers, you all went to good schools, and you practiced, and you know the difference. And what I'm telling you is exactly what's in the law. If you don't want to accept that, that's your, prerogative. But the city attorney, when the mayor's aide was here, the city attorney provided him with a 10-page letter indicating he had every right to delete those entries on his daily calendar. Nobody said you can't do that because the Sunshine Ordinance prohibits it. And your staff wasn't well versed enough to understand that the statute is what controls, not the city attorney's ability to do that. You hit me in a really sensitive spot.
Mr. Chairman, and Mr. Grossman, I look at it from the standpoint of what relief do you want?
I want an order that they have to activate the indices, period.
That who's they?
The planning department.
All right, I wouldn't vote for such an order, but I
don't
would
think we are.
vote for and make a motion to send a letter to the city administrator to put this material up on the website.
Second that.
Any discussion?
I don't know that there is any material to put on the website, according to Mr. Grossman's testimony. But to the extent that
6729 requires that be an active indices. It's totally dead and has been for years.
All right, we need a 67.29 expert. It's beyond me.
So number one is the scope of options that are available to the commission right now are listed in Chapter 3, and so basically they're what you just described, sending a letter to the city administrator, is not one of the options. What's before you is to determine whether these respondents have violated the provisions of the ordinance that have been alleged, which is 67.29.
All right.
So I can read aloud to you what the options are that are available to you. There's, I guess, one is you have to determine if you believe that the respondents here, which are Director Ram and Sarah Jones, have or have not violated willfully the Sunshine Ordinance. So that's one option. You have to make that determination. If you believe that there has been a willful violation, then you can order the respondent, as listed here, to either cease and desist the violation and or produce the records. There's an option to post on the commission's website the commission's finding that there's been a violation. You can issue a warning letter, et cetera. But what's at issue here is whether these respondents have violated the provisions of the Sunshine Ordinance that have been alleged.
I agree. And the problem I'm having is I'm not sure I know what the violations are that allegedly occurred, and I don't know what the response is of the respondents as to why they say they have complied and haven't violated it. And that's we don't hear anything, and there's one way to go in simply saying because they aren't here and the only evidence we have is what Mr. Grossman has presented, and either it appears from that evidence that there's been a violation or there hasn't. But I frankly don't know how to make that determination.
So I would disagree that there's no other evidence before the commission, predominantly because we prepared a staff memorandum that presents our analysis of all the evidence that was presented by both parties during the investigation, which includes Sarah Jones on behalf of Mr. Rahaim and the remainder of the planning department officials. That they didn't appear here today might just mean that they agree with the staff report and didn't feel that the response was necessary or that their presence was necessary. we looked at all of these documents that were produced, which included the EIR. What the planning department concluded was that the amendment to the EIR was a categorical exemption because it didn't have a significant impact on the environment because it was just an amendment. And so they didn't produce a CEQA compliance document. And I think that's the crux of Mr. Grossman's complaint, that the planning department did not produce a document saying why they felt the amendment was categorically excluded under CEQA. But CEQA doesn't require them to create that record. The index to records under the Sunshine Ordinance does not require them to create that record. Nothing in the law requires them to create that record, and so they cannot produce it. Our recommendation is that you find that Mr. Rahaim and Ms. Jones did not violate the law, whether willfully or not willfully, and I should say sunshine law. Whether they violated CEQA by categorically excluding the amendment is a separate question. Yeah. Mr. Grossman has a lawsuit available to him against the city if he firmly believes CEQA was violated. Yeah. That's not the purview of this body.
Well, can we send the letter I outlined? Or would that contradict what you have just advised us of your conclusions?
If you find that they violated the law, if you find that Mr. Rahaim and Ms. Jones violated the Sunshine Ordinance by failing to produce a document exemplifying why they categorically excluded something under CEQA, then you can send a warning letter under the Sunshine Ordinance. But you have to first find that their failure to produce
I withdraw my
create the document was a violation of the Sunshine Ordinance.
I withdraw my second.
Again, I'm calling for, is there a motion that we accept the recommendation of the staff and find no violation?
So moved.
Second.
Public comment?
David Pilpel, I'll try to keep it brief unless you have questions. I'm very familiar with all of these laws and procedures.
Which laws and procedures? There have been many.
The Sunshine Ordinance, the Index of Records, CEQA, Chapter 31, all of the Planning Department and its procedures. I think in this case the staff and the city attorney got it right. I don't think there was any violation, willful or otherwise, by the two named respondents. I think Mr. Grossman is apparently interested in either the Better Streets Plan, which the planning staff identified as case number 2007.1238, and I would suggest the suffix E for environmental if he's interested in the environmental review aspect of it. It appears, is also interested in the Geary BRT project. My understanding is that there's a draft EIR on that that's out. There was a hearing on that draft EIR last year or earlier this year, I think, and that the response to comments is coming, and that document presumably will be certified by the San Francisco County Transportation Authority as the lead agency. Those records exist related to those documents at either the SFCTA or the Planning Department offices. My understanding is that there's nothing that specifically requires all of those records to be available online. Nevertheless, the Planning Department has an environmental planning page, which includes a large number of environmental EIRs and other exemption documents for the last few years. There was an amendment to Chapter 31 in the city about 3 years ago that changed the procedures for how San Francisco implements CEQA. So that's as to the underlying records that it appears Mr. Grossman is concerned about. With regard to 67.29, that dates back to 1993, the original Sunshine Ordinance. It was amended somewhat with Prop G in 1998, but it requires the city administrator to maintain an index of records, which we could call up right now, and is on the web, which identifies types of documents. So as you got in one of the submittals here, case files environmental review under the category major environmental analysis is the type of listing that would be in the index of records. It doesn't have every single document within that type. It's not possible to maintain that on an ongoing basis, just as the Ethics Commission website and index of records will show campaign finance reports without listing every single campaign filer by name or by ID number. Nevertheless, if someone goes to Jared or someone else in the Ethics Commission office and says, I'm interested in such and such a campaign or ballot measure, here's the ID number or something about it, they'll pull up that file and produce it. So the index to records is simply a taxonomy, for lack of a better term, of how the various records of the city by department are organized. It's on the city's website. It has been for 20 plus years. It's been upgraded and updated a couple of times, including the last couple of years. Joan Lubomirsky, who it sounds like Jessica spoke to in the city administrator's office, is responsible for that, and I can answer any other questions. As I said, I think the staff got it right. You've got a motion to find no violation, and I think that's the correct motion in this case.
Thank you.
Thank you. I hope that was helpful.
Any other public comment? Hearing none, I will call the question. All in favor?
Aye.
Aye. Opposed? Record should reflect that the motion was carried 4-0. Turning to agenda item number 7, which is handling Ethics Commission complaint number 1516-23 and 1516-24, Joel Warne versus Nancy Soraya and the Sunshine Ordinance Task Force. That matter has been continued to our December 19th meeting at the request of the chair of the Sunshine Task Force, who contacted Ms. Pelham, I think early in the week before Thanksgiving, indicated that they did not have an opportunity, or would not have an opportunity to submit a response to the staff memorandum, and requested that we put it over to give them a chance to do so. And they are to file whatever response they wish by December 12th, as well as Mr. Werner may file whatever he wishes to supplement his complaint by November 12th.
December 12th.
December 12th, right. Turning to agenda item 8, which is Anne Treboux versus Barbara Sklar. Ms. Treboux, you want to provide the commission with your response and comments on the staff's recommendation?
Chairman, we've had a request for a 5-minute break, if we might.
All right.
Thank you.
We'll make it a 10-minute break till 10 minutes after 7.
SF Gov TV, San Francisco Government Television.
right, we'll proceed now with agenda item 8, which is the Ethics Commission complaint number 16-7-06. 1617-06, and Treboux versus Barbara Sklar. Ms. Treboux, you have 10 minutes. You can respond to the staff memorandum and recommendation, and we'll hear you.
This complaint was originally filed with the task force about a year before that, so it was within the 3-year window when it was actually heard the first time. Unfortunately, David Pilpel was on the task force. He continued to interrupt me while I was presenting the case. He actually sat in the audience with the respondent and kind of goaded them as to how to respond to the complaint. And when he was up there, he kind of baited Kate Patterson along as to how to answer the complaint. And the conclusion was that the Sunshine Task Force lacked jurisdiction because the paperwork didn't necessarily have to reside with the Arts Commission in their office. It would have been in the Ethics Commission office. That was the conclusion of that. So it would have been within the 3-year window if I had directly come here, and I didn't know that I could come here to file a Sunshine complaint at that time. So basically it came about because Barbara Sklar has been the chair of the Street Artists Committee for now probably about 2 years. And obviously she did not know how to run a meeting. She didn't know the rules for it. She didn't know how to handle public comment. And at the first meeting, there were only 3 people in attendance, the Clark brothers and myself. So basically, she was carried out crying because it became something of a shouting match. The security was called, and it was clear to me that there was no order in the room. So I began looking into her Sunshine filings, and while a person can claim that they will take the Sunshine training, there's no paperwork that says I've taken it and here's a test that you can quiz me on that I know the Sunshine Ordinance and as such. In fact, several violations and warning letters issued from the task force against Barbara Sklar in that intervening year for a mistake she made in running meetings. Some are warning letters and some are orders of determination. So there's that. And then, so that basically the introduction in the background it came from firsthand knowledge that this woman doesn't know how to run a meeting. So then I began looking into her paperwork on your database. And because it takes a long time for this information to download, when I originally filed the complaint, there was a lot of paperwork missing for a lot of years. I think going back to 2010. And my concern, as I said, is that she claims to have served under 5 mayors with the Arts Commission. I couldn't find any evidence of that. That would be with the Board of Supervisors, with the supervisors, with the county clerk's office. There would be oaths of office in there. There are none, absolutely none whatsoever. So, and then there are the Form 700s. A lot of them were duplicative when I first began looking in your database. So, a lot of the conclusions that you came across, I think were probably correct when this thing was written in 2016, but when I filed it in August 4th, a lot of the information was not downloaded in your database on your website. So that's why I filed it. And to this day, Barbara Sklar continues to file paperwork saying that she will comply or she will take the Sunshine training, but there's never been any indication that she actually took it or anybody quizzed her on it. And since these things are filed electronically, it's kind of confusing as to who actually filed it, her signature is not there. So when you don't have anybody in person quizzing somebody about meetings or paperwork, or so it becomes very confusing. This woman is 80 years old. She's deaf. She was a political appointee. Her husband served on the Muni something or other. When there was only one record through the Board of Supervisors in 2009, nothing was checked. She claimed to have a background in diverse backgrounds, which in fact all she had is a background in helping elderly people. I don't know what that has to do with street artists, which are street artists. They're a rough grump, a bunch of people. To put an 80-year-old woman who seems seemingly afraid of her own shadow in charge of this kind of group of people is not a good thing. But if she's so scared, she shouldn't have served on it. She doesn't appear at many Arts Commission meetings, about 3 full commission meetings a year, probably 2 visual arts, and 1 street artist meeting. So she doesn't even meet the meeting requirements, but that's not under your jurisdiction. So that's it. She still continues to file these funny paperworks, and obviously she doesn't know how to run a meeting. So how she slipped by all these checks and balances, why her background was never checked out, why her resume was never checked out, making a claim in City Hall in the public record on TV at a Board of Permits and Appeals, claiming she served under 5 mayors, but she can't even remember the names of the mayors she served under, would raise red flags to anybody. And particularly when Commissioner Fong questioned her, she wasn't even responding, because even though she was sitting in the front row, she's deaf. And it was apparent on the video. So, and then she filed that complaint against me, which was totally bogus. But anyway, sticking to this complaint, okay, the statute of limitations timed out, and that's a shame. But she's still continuing to do the same thing. That's it.
Thank you. Any discussion, Commissioners? Dean?
No, Mr. Chair, I just go to the conclusion of our staff that we don't have jurisdiction relating to this matter, so I move that we take the staff's recommendation that there is nothing we can do.
Yeah, I'm afraid we have to. Statute of limitations is getting a lot of attention in this commission, huh? Okay.
Do I hear a second?
Second.
All right. Any public discussion?
David Pilpel, I'll try to be brief, and I'll just ignore Ms. Treboux' personal attack about me. This complaint involves Barbara Sklar, who is the widow of Dick Sklar, who was the general manager of the San Francisco Public Utilities Commission and later a commissioner on that body. She, as I understand, is an artist in her own right and has served for some time on the Arts Commission, and I believe has earned Ms. Treboux' ire by chairing the Street Artists Committee, where they have tangled for some years, resulting in a number of complaints to the Sunshine Ordinance Task Force. On the instant complaint before you, yes, as you heard, I agree that you don't have jurisdiction based on a statute of limitations. Further, that it's not clear to me, even if the statute of limitations issue weren't before you, it's not clear to me what you could do other than write a letter or find a violation. I'm not sure how you can compel someone to fill out this particular form. As I recall, under 67.33 of the Sunshine Ordinance, it simply requires the designated individuals to certify annually that they have read or will read the Sunshine Ordinance and any training materials. It doesn't require a hard date be specified. However, the state requirement, which somebody helped me, was it AB 1822, 1234? Right, like I said. Thank you. Does require a hard date. And so the form, there's a separate form. I think there's a separate form for that, the certificate of training that's different from the Sunshine Declaration. That requires a hard date, and I don't know what the penalties are under that law for failing to file it or on a timely basis or otherwise. I assume that too is governed by the 3-year statute of limitations. So in summary, I think there's nothing you can do on this particular complaint if there are changes to internal procedures that you can make to ensure that the designated individuals do file and have been trained and are maintaining all of their forms. That would be helpful, but I assume that that's underway as part of the compliance review. Anyway, thank you very much.
Thank you. Any other public comment?
I'm walking in with no knowledge, but only a lot of opinions, which is that if someone has not filed, the normal process in the past has been that the commission would refer it to the FPPC, and they will be fined. Usually it's a $200 fine for failing to file. So if there's an issue here that someone has not been filing Form 700s, it should be referred over. You also have, of course, the authority to act on your own on that.
You're commenting in reference to Form 700.
That's it, just Form 700.
Yeah. Thank you. I will call the question. All in favor of the motion?
Aye.
Aye.
Opposed? Hearing none, the motion is carried 4-0. Turning to agenda item number 9, which is discussion and possible action on staff's report and recommendation for handling Ethics Commission complaint number 1516-59, Alvin Johnson versus San Francisco Board of Supervisors. Is Mr. Johnson here? And notice was sent to him that you would be hearing it. I'm going to just summarize the staff recommendation.
Haven't we all read it?
I don't know.
So Mr. Johnson filed a complaint with the Ethics Commission that the Board of Supervisors had willfully violated the Sunshine Ordinance by failing to respond to more than 40 records requests that he had made to them. Upon investigation, it was determined that not only that the Board of Supervisors did actually respond to all of those 40 requests, just not within the 10-day time frame. And that was because of the volume and close proximity of the requests together necessitated the invocation of something called the Rule of Reason, which is actually something that the Ethics Commission itself has done with regard to Mr. Johnson's voluminous requests, just simply because it's not possible to respond to them all within the 10-day time frame when they're submitted so closely together. The Rule of Reason is invoked on advice of the City Attorney's Office in order to allow staff to continue doing their work that needs to be done and not just drop everything and spend multiple staff employees 40-hour work weeks responding to requests. So staff recommends that that the Commission find no violation of the Sunshine Ordinance, predominantly because eventually all requests were responded to.
Mr. Chairman.
I hear a motion.
I will move that we find the Board of Supervisors didn't willfully or non-willfully violate the Sunshine Ordinance.
Second?
Second.
Any discussion among the commissioners? Not any public discussion?
David Pilpel again, very briefly. In my time on the Sunshine Ordinance Task Force, Mr. Johnson was before us physically once and filed a number of other complaints that were subsequently dismissed for lack of prosecution. He, as I recall, was a former city employee who was who's no longer with the city, and he became very upset about how all that happened, in particular with the Department of Technology, and has subsequently filed a large number of requests with various agencies, including the Department of Technology, Human Resources, City Attorney, Retirement, Civil Service, Board of Supervisors, this commission, the list goes on. The city, through its various departments, as I understand, has used this implied rule of reason on a case-by-case basis in a very limited number of cases with Mr. Johnson, with one or two other people over the fullness of time, but very rarely does it have to come to that. In this case, it simply was necessary, as I understand it, and so I would agree with the staff recommendation that the Board of Supervisors has complied with the ordinance. There was no violation. They have spent hours and hours, as has your staff, in responding to requests from this individual. Thanks.
Thank you. Any other public comment? Hearing none, I will call the question. All in favor?
Aye.
Opposed? Hearing none, the motion is carried 4-0. Turn to agenda item 10, which the discussion of Education and Compliance Division report. Mr. Peterson, or who is making the presentation? Mr. Flores?
Yes, good evening,
good.
Commissioners. I'm going to be talking about what's going on with our campaign finance program. And so we produced our SF Ethics Info Election 2016 infographic. And again, just like what we did last time, is we wanted to produce kind of a snapshot of a story of this past election. And a lot of money has been raised and spent, either for ballot measures or to support or oppose candidates this year. And again, the purpose of this handout is to really highlight our dashboards page to let the public know that they can utilize this information to find out information about what's going on in their particular jurisdiction with regards to the candidates that are running, how much are they raising and how much they're spending. And of course, importantly, is how much independent expenditures are being affected in those races. Another important distinction I want to make is, sorry about that, is that of all the many years that I've been at the Ethics Commission in terms of monitoring campaign finance, this has by far been the most busiest election I've ever experienced. And this on the handout, it goes to show that the number of electronically filed campaign statements has literally doubled this year. And while our staff is still growing, we've been able to handle a lot of the monitoring of the campaign statements, as well as disclosures that are involved with these types of campaign statements.
Thank you. And I thought it was I appreciated the memorandum that you filed. I thought it was very helpful and informative. Any comments or discussion among the commissioners?
Chair Rennie, if I might also add one thing. Pat Peterson couldn't be with us this evening, but she, of course, works with Jared in our Education and Compliance Division. Following, I believe it was actually the day after the election and the voters' approval of Prop T with 87% of the vote. We provided to those who are registered as lobbyists, other law firms, permit consultants, major developers, a whole host of individuals on our various mailing lists, a copy of the FAQ on Prop T that it's attached to this report as well. Just wanted to flag that for your attention, because even though the law becomes operative on January 1st, 2018, we know that it's important for folks to start understanding how it might apply to them and to begin to contact us with any questions. So I just wanted to highlight that for you as well.
Thank you. Any public comment?
Larry Bush for Friends of Ethics. I'd just like to express our appreciation to Jared for the help that he gave us in making sure that we were able to comply. As you can imagine, how humiliating it would be if Friends of Ethics was not in compliance on filing its reports. And Jared was very helpful in making sure that, to the extent that any fault existed, it was on our side. Thank you.
Thank you. I'll turn to agenda item 11, a discussion of the Executive Director's report. Ms. Pelham.
Thank you. I am very happy to share with you news on the staffing front. First, we have a new staff member who will be joining us as our new senior clerk in the front office. A very small front office, but a front office nonetheless. Jacqueline Hickey will be joining us on December the 12th as our new senior clerk. She's got a background in customer service in the private sector, so we're very excited about her coming on board and getting up to speed very quickly with all of the work that we have ahead of us. I'm also wanted to highlight for you sad news, but news that Catherine Argumetto, who you have been used to seeing here at the commission meetings regularly, but also one of our investigators, decided to pursue an opportunity to resume her private practice of law as an immigration attorney. So she left our office on November the 10th, but we were glad to be able to give her a bit of a farewell in the office and spend some time with her, thanking her for the work that she's done, and I think in her 10 years here. Particularly notable over the summer when we were down to one investigator, having Garrett Chatfield having left for a promotional opportunity in the city. Catherine did a terrific job of really keeping the complaint process on track and responding as timely as she could to incoming complaints. So she did a terrific job with the able guidance of our deputy director. But I wanted to, on behalf of all of us, announce that she had left the commission and to thank her for her commitment to the work of the commission and the contribution that she made during her time with us. Also, at the end of this week, Francis McAvoy and Jack Canese, who have been with us as staff assistants, temporary part-time staff assistants, their term with us is coming to an end since the election is ended, but they made Jared's life possible over the last few months and really were very helpful in making sure that those who had requirements with the law were able to get the information they needed to comply with the law. So they have both been terrific assets with us, and we will be missing them as well. Separately, we do, as of today, we have 3 positions that closed. They were in recruitment, the 3 senior investigator or investigator legal analyst positions. So we'll be moving along in that process. That is a senior civil service hiring process, but we look forward to keeping you informed about that. The recruitment also closed recently for the senior policy analyst position and an education and compliance assistant. And so I'm hopeful that we'll have some news for you on those 2 fronts at the December meeting as well. I did provide also an update of the November policy plan. As you might imagine, with a lot of the focus of my time on all things hiring and some of our staffing changes that we've seen, some of the items have been pushed further into 2017. So I very much welcome conversations with you as we go forward, but about how to prioritize these if you would like to see some different priority order. But I just wanted to highlight for you that a number of the items that we were hoping to get to have been pushed back by a couple of months. So I'll continue to keep you apprised from the staff's perspective about where these might be landing. But we do want to continue to try and put a priority focus on our public financing report post-election so that we can bring that forward as planned in the early part of the year and have some discussion about the public financing program as we start our process longer term of looking at the campaign financing system here in the city. So I just wanted to highlight those items for you, and I'm happy to answer any questions you might have.
Any commissioner have any questions?
I have a question. Director Pelham, since Catherine has left and she was our last investigator, how will you be handling, do you have resources to handle the incoming and ongoing complaints?
We do. It's a secret weapon called our deputy director, Jessica Bloom. But we will. The reality is that we will have to pull in staff as needed, depending on the nature of the issue. I think one of the challenges in particular will be that following the heels of a busy election season, and you've seen on the chart that Jessica provided to you, there are 89 matters under preliminary review. Those matters will continue to be in preliminary review, and she will continue to work through them. But obviously, it's juggling quite a bit with other policy issues, a review of the Sunshine Ordinance, a review of our enforcement regs. Some of those things are simply going to have to take a backseat to making sure that we triage any complaints or investigations that need to continue. So we will be using other staff members as possible, depending on the need that we have and the particular background and skills that they bring as well. But again, today's good news was that we have 3 positions that were in recruitment, and we're hopeful that we will have a strong candidate pool to bring in folks in the early part of the year to help us with going forward. But in the meantime, it will be triage as best as we can, and we'll keep you informed. Thank you.
I have a question on page 4 of the report where you set out the revenues and you show revenue for statement of economic interest filers. Explain that. Do you have to pay to file a statement of economic interest?
No, you do not. You do have a late fee if you file late. So we could probably be clearer in future charts to make sure that that is clear, that it's not a fee for service, but a fee for a late filing.
Thank you.
Other questions or comments? Public comment?
David Pilpel, once again, just wanted to thank the staff for a comprehensive report, and in particular the chart, one of my favorite documents. There were a number of these items I would suggest would lend themselves to an interested persons meeting, so that before something is brought to the commission, for example, the enforcement regulations, which I would think are going to be complicated in a lot of pieces and a lot of changes, that we have at least one, maybe a couple of discussions with people who care about these things and say, well, this is how it currently works, this is what we're proposing, what do you think, can we schmooze about it, all of that. And I suspect you'll have a better proposal before the commission as a result of that. And maybe offline someone can tell me, I must have missed this, the citywide relationships policy, it's not at all obvious to me what that is. Is that personal relationships? Is it among departments? Is it sometime you can explain it to me. Thank you.
Thank you. Turning to agenda item 12, discussion and possible action regarding status of complaints received or initiated by the Ethics Commission. And I'll first call for public comment on agenda item 12.
David Pilpel, in my experience, I think this is the first time in its history that the Commission has gone into closed session in general terms to talk about the status of enforcement matters. Obviously, you've had closed sessions on particular matters over the years, but I think this is the first time you've looked at the enforcement program in terms of specific cases that are outstanding. So that's fine. I hope you'll talk about the status of things and maybe priorities. If there is a discussion about prioritization and ways to triage and which things should be handled sooner rather than later and whatnot, if there's a way that you can make that part of the discussion public or the results of that, I think that would be all to the good. I think we would be interested in knowing how you would hope to prioritize the significant caseload that you have now and what's ongoing. Obviously, things that are older should take some priority, but if things come in more recently that are of more significance or magnitude in your judgment or the judgment of the staff, that too would make sense to prioritize. In any event, however you come out with that, the public, or at least some of us, would be interested in that. Otherwise, I hope you get through figuring out what to do with that big caseload and reducing it. Thank you.
Thank you.
With that, I'll bid you good night.
Why do we go into closed session on?
I don't know if there's more public comment. We will go.
No, but why? Why can't we talk about all these publicly?
Because they're all confidential until such time as
the charter requires confidentiality.
Right. Charter requires it.
Yes.
All right.
Anyway, thank you all very much. Good night.
All right.
Any other public comment?
I'm a little bit in the dark as to this Larry Bush for Friends of Ethics as to exactly how broad your review will be. But one of the issues that had come up earlier was the process for selecting committees to be audited. And a motion was made at that time, but not accepted, that you audit the committees that were under criminal investigation. for money laundering. And the decision was that they would be selected out of order, and instead the commission was operating under a process of selecting things at random rather than with a priority. I'd like to suggest that as you look at these issues, if you do have criminal charges that have been in the press and so forth, it would be well advised for the Commission's credibility to elevate those beyond what might be selected by random, to make sure that they are audited and the public is aware that you would audit them. Thank you.
Commissioner Keene?
Just a comment for the record, Mr. Chair, and sort of following up on Commissioner Kopp's observation, and going back to what we discussed. That was something that I brought up the last time, that in regard to these matters, the question of making probable cause determinations and the question of the fact that there has been a complaint filed, there's really no due process requirement that we have all this confidentiality. And I would echo what I had said the last time in regard to the discussion that Ms. Pelham, sometime next year, we really engage this matter in regard to having these secret, closed, probable cause proceedings, and also all of the other aspect of confidentiality. It's the charter requires it. I don't think it's necessary, and I think the public has a right to know both of the complaint and of the probable cause matters, how the probable cause matters are dealt with, and that's something that I hope we take care of within the next year.
Do I hear a motion that we move to assert attorney-client privilege and meet in closed session with the city attorney?
So moved.
Oh, for attorney, yeah. Certainly, I'll second.
And all in favor?
Right.
Aye.
Aye.
All right.
SF Gov TV, San Francisco Government Television. SF Gov TV, San Francisco Government Television.
this? Which station is this on?
26.
26. And there's another one.
SF Gov is what it is.
Yeah. But there's another one too, isn't there?
For San Francisco stuff? I don't know. I know there's C-SPAN on 24.
That's C-SPAN.
It's on
I
24.
thought there was another San Francisco.
Could be. That's possible. 26 is the one that.
You think we'll win our time slot? Do you think we'll win our time
Rita
slot
Simmel.
in the Nielsen ratings?
Simmel said, she said
TV
she's going to
programs?
watch us.
Oh, I think so.
Yeah. Where do you see Rita?
I saw her at the Reverend Amos Brown's 40th anniversary last Sunday at their church.
Yeah. Yeah, good for Rita.
I said, I can't believe anybody really watches this stuff. But occasionally I run into somebody, say they watch it. I said, have you got anything better
Our
to do?
candidates thought so.
That's what I would suggest.
Have you got anything better to do?
It's usually the simple stuff that does.
Neither was elected. It shows our effect.
All right. All right, Commissioner Kopp, I think you were in the middle of your comments.
A large percentage, not a plurality, a majority of these 30 plus or minus pending matters are attributable to deferring to a request by the district attorney to abate our investigation while the DA investigates. And some of those requests, as the chairman noted, go back to 2013, as others are 2014, others are 2015. They're at least a year old. And that does a disservice to the people of San Francisco. Does a disservice to this commission, which tries to execute its responsibilities. And I have marked, and I will initiate a motion as required to seek a return or a reinstitution of our own investigation in about 20 of these cases. And alternatively, as the agenda indicates, the Commission can formulate a policy for the guidance of the public and the district attorney as well, putting a time limit on the district attorney's request for us to abate an investigation with a provision in the policy that at the end of that period we resume our investigation and take action. I don't want to see a repeat of what happened in this Farrell case, for example, with the statute of limitations running. And that's a bona fide concern. Justice delayed is justice denied. It's trite, but when you look at the report, pending matters, it's true. Thank you, Mr. Chairman.
All right, turning to agenda item number 13, discussion and possible action on items for future meetings. I think we had public comment on agenda item 12, and we're now on agenda item 13, and agenda item 14 allows for further public comment, and I would suggest, Mr. Bush, that you can make your comments at that time. So on item 13.
Mr. Chairman.
Yes, Commissioner Cobb.
I should like to request an investigation by our staff of the following apparent facts. A committee known commonly as No on DHL&M was formed. DHL&M refers to propositions on the November 8th the San Francisco ballot to raise money to defeat each of those measures. The San Francisco Chronicle reported on or about November 9th that with the mayor's help, and I quote, with Lee's help, the No on DHL&M campaign raised and spent more than $2,200,000, about 10 times as much as was spent to support them being the ballot measures, DHL&M. A second fact is that a person named Tony Winokur, who's described as a senior advisor, took a leave of absence from the mayor's office and managed the campaign to defeat all of those four measures, and is quoted as criticizing the San Franciscans who were responsible for those being on the ballot, including various members of the Board of Supervisors. I'm informed and believe that Mr. Winiger isn't registered as a campaign consultant. I'm informed and believe there's no Form 700, the state form on Statement of Economic Interest, on file for him. And it appears that there is evidence, and it appears there's justification for an examination and investigation of all those circumstances as to whether the committee mentioned is a candidate-controlled committee or was a candidate-controlled committee if it no longer exists, controlled by the mayor, and that the requisite campaign statements were not followed or filed as a candidate-controlled committee. I think that sums it up, and I'll provide any other information that I have to shorten the time required.
Any other suggestions for items for future meetings? Public comment on? Hearing none, go to 14, which is now an opportunity for public comment on any matter, either on or off the agenda. Or Bush?
As a reporter, a few years ago, I did an investigation with sunshine ordinance request to the Ethics Commission Executive Director and to the District Attorney for a record of referrals for action that went from ethics, as the charter required, over to the District Attorney. I received, and I asked for them without identifiers because of the confidentiality issues. I did receive a list of some referrals. But the district attorney then provided a formal written response that they had no record of anything being referred to them by the Ethics Commission. So it was clear that there is a miscommunication that was taking place. It also would appear that nobody had a tickler system that paid attention to when these things are. So the fact that you are putting on your agenda an examination of this, I would just like it to be on the record that we did, I did do that through the Sunshine Ordinance, and I did establish a record that it was not being done. As a former member of the civil grand jury, there are certain confidentiality standards that I cannot further disclose, but if you read the ethics report from the 2013-14 Civil Grand Jury Report on Ethics, you will be able to discern that additional information emerged about the gap in follow-up at that time. Thank you.
Thank you. Hearing no further public comment, somebody move for adjournment?
So moved.
Second.
Right. All vote. All in favor of adjourning?
Aye. Aye.
Opposed? We are now adjourned. What is the date?